Great. So we are going to ask you question 3. And I will read the question and then ask you to give us your statement. So, Aristotle asserts in Politics that it is not the form of government, the rule by the one, the few, or the many that matters most, but rather the ends of government that are most important. Where in the Declaration of Independence and the Constitution did the framers set forth the ends of government? How did the framers differ, if at all, about how the ends of government should be prioritized? Which of the ends of government set forth in the Declaration and Constitution appear to have the highest priority today? You may begin.
In Talos, Aristotle asserted that the goal of humans is happiness, which can only be achieved through virtue. Therefore, governments must promote virtue through laws and education. Quote, "The lawgivers make the citizens good by inculcating good habits in them. And this is the aim of every lawgiver. If he does not succeed in doing that, then his legislation is a failure." Unquote. The framers believed that both Aristotelian virtue and individual liberty that came out of the Protestant Reformation and Enlightenment were essential to human happiness.
Therefore, the framers ingrained virtue and the protection of natural rights in the Declaration. The preamble states that, to effect safety and happiness, governments must protect inalienable rights of life, liberty, and the pursuit of happiness, and that governments derive their power from consent. It is followed by a list of grievances that were focused on the abuse of governors and their restrictions on the General Assemblies. The denial of self-government and natural rights forced the colonists to abandon the social contract because the ultimate goal of government became unachievable.
Both virtue and rights are central in the preamble of the Constitution. The framers declared, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty as the goals of the Constitution. The protection of virtue and rights was expanded with the Bill of Rights, specifically the First Amendment.
Classical Republican ideas to promote the common good can be shown in Article 1, Section 8 for the taxation and control of military clauses. Classical Republicanism was also promoted with Articles 4 and 6, which provide for a Republican government close to the people through federalism, as well as the Fifth Amendment, which states that people's private property can be taken away for the common good of society.
While the framers agreed that human happiness was the goal of government, they disagreed about how happiness was best achieved. John Adams emphasized virtue and safety, while Patrick Henry emphasized the protection of individual rights. Madison, Hamilton, and Washington were concerned with economic rights, as seen in Article 1, Section 10, which directly targeted states like Rhode Island that had violated contract rights and provided debt relief at the expense of the wealthy. Adams, in Thoughts on Government, explained that government should promote moral and civic education, drawing on classical Republican ideas from Cicero and Aristotle.
Today, our courts see more focus on expanding natural rights than classical republicanism. Using incorporation, the Warren Court began a revolution in individual due process rights, with cases like Gideon v. Wainwright leading to cases today, like McDonald v. Chicago and U.S. v. Jones. State courts also play a key role in expanding natural rights, with cases like Goodrich v. DPH, which was later implemented on a national scale with Obergefell v. Hodges.
More often, legislatures focus on promoting the common good to promote human happiness. The Affordable Care Act extended health insurance to millions of Americans. The Brady Handgun Act was created for the common safety and security while limiting some fundamental liberties. State governments with police powers focus most often on the general welfare and safety.
In a national emergency, the government often prioritizes safety and the common good. For example, during the current COVID-19 outbreak, government actions to shut down non-essential businesses, close schools, and shelter in place protect the common health and therefore happiness of society. However, when there is no national emergency, the government often fails to cooperate and therefore fails to prioritize the common good. In 2014, Congress failed to pass the Immigration and Modernization Act, hurting the common good of society.
In Politics, Aristotle argued that successful constitutions, regardless of structure, need good laws and moral education to guide humans towards virtue and happiness. The framers believed that both Aristotelian virtue and individual liberty were essential to human happiness. We believe that the Massachusetts Civics Law is leading the way to help youth understand the role that governments must play in protecting rights and promoting virtue. We cannot just focus on one pathway to happiness, but we must seek a balance in protecting virtue, liberty, and safety. Thank you. We're ready for your questions.
This was really interesting. You guys talked about happiness and virtue and moral education quite a bit. There are 4 classical virtues that Aristotle and Cicero wrote about. Do you think we should teach those four virtues, and do you think we would be a better society if we did teach those virtues in public schools?
I believe that we definitely should be teaching these virtues that Cicero and Aristotle had illustrated, like you mentioned. I think that classes like We the People are actually really helping to do this because it's allowing our youth to become more educated in society, and therefore for their future, they are better, they're better to be able to participate in their government and really know what government is about.
And also the framers really intended for these virtues to be taught. In the Virginia Declaration of Rights, George Mason actually mentions in section 15 the 5 virtues, which are temperance, moderation, frugality, justice, and moderation. And the framers actually instituted this into the actual Constitution. We see the ideas of justice really being secured with the Bill of Rights, the Second Constitutional Convention, and we can also see a huge focus on the justice that was lacking in the states during the Articles, with protections of economic liberties in Article 1, Section 10, which directly responded to the state of Rhode Island and the idea that you can't give people, the creditors, money that isn't valueless, like chickens or paper money at the time, and that the government should not be involved in the contract rights.
I understand where colleagues are coming from, but I quite frankly disagree with them. I think that when Aristotle was talking about his ideas of cultivation of virtue and his virtue ethics theory, he was stating that moral virtues you can't learn through education, and you can't learn from other people forcing them on you. It has to be done through your own practice until it becomes habitual and you're able to reach the state of eudaimonia, or what he considers like fulfillment, which is happiness. It's like moderation is something that you can only learn through your own doing. It's very individual.
Okay, let me pick up on that. It's very individual in the sense that it's not about government, it's about the person, it's about the individual. What about the role of society? So again, not government, not the laws, but society. Are we flourishing as a society, and do we have enough consensus on the ends of government? Do you think we're suffering from too much polarization? Does social media tear us apart too much? What do you think about all that?
Well,
I-
you can go, Josh.
Okay, so we have a system where we think that the end of government is happiness, but there's 3 ways to get to that. Those are civic virtue, security of the common good, and natural rights. I think that one way that people can promote happiness is being civically virtuous, and we can see this with things like the voting amendments, the 15th, 19th, 24th, and 26th, which help people to get involved in government. And I really think it's people's jobs to get involved in government in order to be happy. And Adam Smith would agree with this through his rational choice theory, which states that if people have the choice to be virtuous or to seek immediate gratification, they will seek immediate gratification. So I think we need to teach people to be virtuous so that they can learn to be happy over time.
I know you wanted to stray away from the idea of government and its role in this, but I really do think it's crucial to the lack of civil discourse that we have in today's society. This really stems from Congress and the fact that political party lines are more important than promoting laws that actually benefit the happiness of society. For example, like we talked about in our statement, the Immigration and Modernization Act wasn't passed in 2014, and we have a huge immigration problem in this country that needs to be solved with a law that would better promote happiness and the security of our nation. And the civil discourse that we're really lacking right now stems from those political parties. And George Washington warned against this in his farewell address, and he said that if we didn't have political parties, it would better benefit the happiness of our society. And we should have listened to him, because now—
Solutions. Thank you. What are some solutions?
I think that really the way that we can get to promoting all 3 pillars in terms of getting to happiness is by taking Aristotle's idea of the golden mean and applying it to government. And we see aspects of that, so it can be done. With the 1994 Law Enforcement and Crime Prevention Act, which helped put in place common sense gun regulation, such as the assault rifles ban, we can reinstate that. It expired in 2004 with its sunset clause. We can do things like repassing that, and that will help us achieve happiness, because we'll be able to find a compromise between all those.
Also, I think the Supreme Court has taken a huge role in promoting the happiness of society when Congress has lacked at it. So we really see this with the creation of the 14th Amendment and the Due Process Clause, which allows for substantive due process, which expands the rights of people which therefore allows them to pursue their own happiness as was intended in the Declaration of Independence when it stated pursue your own happiness. So by doing this with cases like Loving v. Virginia, which protects the right to interracial marriage, Griswold v. Connecticut, which protects the right of women to have contraceptives, and even Roe v. Wade, which protects the right to abortion through privacy to women, we're expanding these rights and allowing people to pursue their own happiness.
Would you agree then that the incorporation and the incorporation doctrine then relates directly to happiness and then the idea of good government?
100%. I think with cases like Chicago v. McDonald, which does incorporate the right to guns, although I think gun regulation is crucial to having the compromise of security, the common good, and natural rights, I think incorporating these rights better protects them and better serves to the happiness of the people.
Time.
That worked out very well. Look, you guys are the first group we have had that has emphasized civic education and virtue so much. And I think that's really crucial because Aristotle's Politics is actually his sequel to the Nicomachean Ethics. It's a moral treatise. One of you brought up Adam Smith too. His Wealth of Nations is a sequel to his moral treatise. These are moral tracts. So I'm really glad you brought that up. You guys are good. I mean, you guys are very, very good. I liked how you all worked off of each other. I liked how you gave specific examples from American jurisprudence and legislative history. But I also liked how you saw the bigger picture in the Aristotelian theory. I thought the emphasis, you knew when I asked you the question about the civic virtues from the classical world, you knew what they were. And you talked about how Mason rolled them into the Virginia Declaration of Rights. This was very good. I really enjoyed listening to you guys talk.
Thank you.
Thank you.
I also really enjoyed it. I enjoyed how you didn't only know the history and the philosophy and the law, but you drew on all of that knowledge and preparation, hard work to express what you think is most important to you as a citizen right now in our society. That's the point of all this. Even the highest level philosophers, that's at the end of the day what they were concerned about. As my colleague said, these were moral treatises. They were trying to figure out what's the right way to live, what's the best that we can do for ourselves. And I could see you guys today doing that. You have a genuine care. You're not just trying to say what you know and what you've read. You care about your life, your society, your fellow citizens, and you're drawing on this knowledge and preparation and the hard work that your teacher has helped you to do to figure out what's most important. And you have a care and concern. You have a civic virtue for your fellow citizen. That's really good to see. I know that you will value this as you go forward because compared to any other unit, this equips you with a certain resilience in terms of mind and morality that you can carry through your whole life. And I really hope that you do always value it, because you're going to learn a lot more important. You're going to continue to learn at a higher level, but this is always going to be a very foundational experience. And I just hope you never underestimate how important it is.
Yeah, I have to echo exactly what was just said. I mean, I can tell you the notes I have on my page, I wrote down lots of examples, very, very smart. I wrote down wow and circled it. And so it's not even just like a bad old Batman cartoon. I mean, you guys know what you're talking about. I was extremely impressed with how well you all worked together. I liked the examples that you were giving me. I liked how you talked about incorporation. I don't think anybody's talked about that yet. And that's after I was already impressed with you being able to name the virtues, discuss the classical texts. You tied things right back to the old theory. And to echo what my fellow other judges said, if there's one thing that's key about Unit 1, and we actually were just talking about this offline, the three of us, If you understand these fundamentals, what changes in the way in which you can relate to social media and the way in which the world looks and operates is truly extraordinary, because when you understand the basics, you can see things happen and you can understand why they happen in the system. And it's very clear to me that all of you have that ability. You all are very smart. Your answers were right on point. And just like my other fellow judges, I was very impressed. You should be very proud of yourselves today.
Thank you.
Thank you.
Thank you.
Thank you.
Nicely done, students.
You may begin.
The need to alter the Articles of Confederation was obvious during the Confederation period. Taxation and commerce amendments that would have addressed its problems failed to pass the unanimity threshold. The inability to amend the Articles, combined with events like Shays' Rebellion, led many Americans to believe that something drastic needed to be done. The failure of the Annapolis Convention led nationalist leaders like James Madison and Alexander Hamilton to appeal to the Continental Congress for the approval of a second convention.
The Philadelphia Convention was approved for, quote, the sole and express purpose of revising the Articles, close quote. All decisions made by the delegates were subject to the approval of the Confederation Congress and the states. States like Massachusetts provided explicit instructions for what could not be changed, such as the requirements for rotation, annual congressional elections, and the power to recall delegates. These mandates were ignored by the framers.
Rhode Island's refusal to send a delegation prevented them from achieving unanimity and provided an excuse to create a new, stronger form of government. While the Articles have been influenced by the injustices suffered under a strong, distant government, the framers at the convention were influenced by their experience under weak central government and state constitutions. Historian Donald Lutz argues that the state constitutions can be broken into two waves: first wave constitutions written immediately following the Declaration of Independence, and second wave constitutions written later and avoiding mistakes of the first wave.
The first state constitutions were heavily Democratic, with the majority of power placed in the legislatures. Legislators in states like Rhode Island faced enormous pressure to respond to the demands of the people. Historian Michael Klarman argues the legislatures were exceedingly responsive when they enacted comprehensive debt relief and issued paper money. They struggled to pay off debt, collect taxes, and maintain stability among constant legislative turnover. Many aspects of the Constitution, such as Article 1, Section 10's restrictions on states, were in response to actions taken under early state constitutions. The framers also rejected the structures that created problems, such as Pennsylvania's weak plural executive and annual elections found in many states, which made it hard to maintain stability.
However, the framers actually drew inspiration from second wave constitutions, whose complex system of checks and balances and centralized power enabled them to better resist populist demands. They drew especially from the Massachusetts Constitution, whose strong independent executive and numerous internal checks Even second-wave constitutions faced structural problems, as seen through Shays' Rebellion and the revolution at the ballot box that followed. Ultimately, the creation of the Constitution was a culmination of the positive and negative experiences of the framers that forever altered the trajectory of American history.
The Supreme Court's actions ensure that America continues steadfastly on that path, occasionally recalibrating constitutional principles for modern times. However, they do not act as a continual constitutional convention. The Supreme Court's job is to interpret the Constitution, and while they have expanded that power through decisions like Marbury, McCulloch, and the creation of substantive due process, their actions do not alter the basic structure of government.
Political scientist Akhil Amar argues substantive due process acts as a way for the courts to further the principles articulated in the founding documents and serve as a way to protect evolving national values. Substantive due process, established in the 14th Amendment, allows the Supreme Court to protect individual liberties that are deemed fundamental to ordered liberty and deeply rooted in historical tradition.
The use of substantive due process brings the court closest to judicial activism, but extends the principles of the convention. They establish what rights are fundamental, such as establishing the right to have children in Skinner v. Oklahoma, the protection of interracial marriage in Loving v. Virginia, the protection of abortion in Roe v. Wade, as well as the protection of same-sex marriage recently in Obergefell v. Hodges. These decisions play an integral role in ensuring that a government of the people can adapt to modern challenges and protect the rights of all people. Thank you, and we're ready for your questions.
Well, great. Let's jump back to history a little bit. The Anti-Federalists didn't like the Constitution, but they also didn't like the convention. So what were some of their arguments against the convention itself?
So one state, Rhode Island, didn't even show up to the convention because they thought it wasn't necessary. And they believed that under the articles, it had an amendment process and that amendment process should be used, Article 13 of the Articles of Convention, to amend it instead of creating a new document or coming together to fix them, because they could already call convention, amendment conventions. So it was unnecessary to call a different kind of convention.
I think that another major concern was that the convention was held in secrecy. Patrick Henry himself said, "I smell a rat." And I think that that is so true for the people who weren't as involved in the convention's process.
So you talked a little bit about substantive due process and the expansion of civil liberties. But of course, most of that rests on a constitutional amendment, right? The 14th Amendment. So is the 14th Amendment an invitation to judicial activism in a way that the original Constitution is not? Or how does that change things?
I don't believe it is, because judicial activism, though it has been argued that it's really just a criticism of the court that they are making law rather than interpreting it. And I personally don't believe that they do this because they spend so much time to ground their decisions in the Constitution.
In continuation off of Emily's point, Justice Roberts, in an interview on judicial activism, said that the courts like to act more as an umpire in the rulings rather than an actual player.
I disagree that the courts use judicial activism, but I don't think the 14th Amendment gives them more leeway to do so. In the Sebelius case, regarding the Affordable Care Act, the court ruled that using Article 1, Section 8, Clause 3 to force people to take part in interstate commerce was unconstitutional, but then they took that a step further and said instead you can tax them under Article 1, Section 8, Clause 1. And additionally, in doing that, they made a bill that came out of the Senate have to do with taxation, which violates Article 1, Section 7. So I think that is very clearly judicial activism, but it is based on the body of the Constitution, not something that came out of the 14th Amendment.
Okay. One of the things I haven't heard you say much about is ratification. Was the ratification of this document a foregone conclusion, or what was involved in the politics of ratification?
So Massachusetts handles ratification by proposing amendments to the Constitution. Some of the amendments we now see in our Bill of Rights, such as the 5th Amendment, the 7th Amendment, and outside of the Bill of Rights, the 11th Amendment, which later overturned Chisholm v. Georgia. Massachusetts also, they address the vagueness of Article 1, Section 3 with representation, and they also address Article 1, Section 4, Clause 1, which has to do with when Congress can intervene with elections.
So New York took this in a very different way than Massachusetts, with the need that New York needed to ratify the actual Constitution, or else our nation would have been divided. Federalists like James Madison and Alexander Hamilton came out with all the Federalist Papers that we know and love today.
Another state, Pennsylvania, ratified the Constitution very quickly, and the majority knew that they would win, but they didn't want the minority to have a chance to speak or to influence other people. So they ratified it very quickly, but the minority coming out of that published the minority of the dissent of the Pennsylvania ratification and suggested changes that they thought, they had substantive changes that were all denied, but some of the personal liberty changes are seen today in the 1st, 4th, 5th, 6th, and 7th Amendments.
On the opposite end of the spectrum, some states like Rhode Island held out until they were forced to ratify. They were threatened to be completely barricaded off. And then South Carolina waited until the Bill of Rights was promised to them and they were guaranteed that they would have that Bill of Rights.
How long do you think the other states would have waited for Rhode Island?
Well, they didn't need approval from all of them, so I think they would have just moved right on.
Okay.
Hey, how representative do you think these guys were at Philadelphia?
I don't think they were. I think the Constitution is just a continuation of how the government had been before. They were mostly white male land owning the elite, and so I don't think they did a good job at representing everyone, especially as women, African Americans, any minority wasn't really represented at the convention.
Does that mean the ratification conventions are better than the Philadelphia Convention in terms of representation?
I think in some ways they were, in which the states could decide who could vote, and so different states had different rules. Like Pennsylvania allowed any white male to vote. They didn't have to have large property requirements. But I don't think, looking at how democracy ideally should represent everyone, I don't think they were better because they still excluded those other classes.
And you get the last one, Sadie. Well, thank you.
Thank you.
I guess I'll start out. I thought your opening statement was very thorough, and a reference to Don Lutz and his framework of phase 1, phase 2, I think was you used that very effectively to distinguish that there are different. There's a sequence to this. I also think your argument about and I would have been shocked if you had not referenced the Massachusetts precedent. I mean, this is your chance to toot your own horn, and you did so quite well. The question on ratification being foregone, fantastic answer. In knowing that the Pennsylvania minority gets suppressed, but do find a way to publish their critiques. And I might add, they circulate throughout the rest of the country for the next year and a half. The Pennsylvania seceding assemblymen and with dissent of the minority come, And I think especially interesting, that ratification conventions, the state requirements for voting altered for those state ratifying conventions. That's important. Now, I think to Sadie's point, was that any better? Well, a little bit, but the fact that you knew that is important. So I think there's a lot to think through here. I'll let my colleagues handle kind of the political sciencey stuff. Gentlemen?
Go ahead, Jack.
Okay. Yeah, I appreciated the thoroughness of the opening statement as well. I thought, like my colleague, I thought it was a very good use of Don Lutz's arguments and the phasing of the different constitutions. And you also used some of the bad examples from state governments, and that was important, right? What not to do was just as influential as what worked. So yeah, the Pennsylvania minority, I mean, coming from a part of Pennsylvania that probably voted against the Constitution, that would have been against the Constitution if there had been anybody living here at the time, any white property owning males living here at the time. So yeah, I mean, I thought it was really thorough. I thought on the Supreme Court, though, I thought you got in a little bit of a dangerous area talking about the use of substantive due process, because that's really something that only comes after the 14th Amendment, or only really becomes possible after the 14th Amendment. You know, how that shows the Supreme Court as a continuing constitutional convention is not altogether clear, because it doesn't necessarily have structural implications for the federal government. But you use the Sebelius case, perfect example of how the Supreme Court uses a federal, interprets the federal Constitution for the federal government and makes changes. So I think of all of the examples, if you only picked one example, that was a really, really good one to pick. So I congratulate you on that. Clearly you have been discussing this and thinking about it and arguing about it, presumably arguing with your teachers about it and your coaches, which is good. Keep doing that, okay? Argue with us old people because we don't know everything. Some of us don't know much about anything. And so, as you learn about it and as you apply this knowledge to new circumstances, new situations, I think your conversations are going to get richer, going to be more interesting. And I really thank you for the chance to have this conversation here this morning.
Yes, thank you. The third judge gets to agree with his colleagues, and
there's room for a dissenting opinion.
Well, I only have a couple of things to quibble about. One, I want to reclaim Don Lutz. You referred to him as a historian. Don's a political scientist, was in my department when I was in graduate school. So I felt like saying, I know Don Lutz. Don Lutz is a friend of mine, but that's in a different political context. The other quibble, I agree with the Jack's comment about the courts. You took a clear position. I thought it was a defensible position. I would have liked to have pushed you to look at other types of decisions. They still could have supported your position, but it requires a more nuanced understanding. I think you got that. I was impressed with your depth of understanding. The other quibble I had was about referring to the Federalist Papers that we quote know and love today. I always tell my students that I think one of the worst things that ever happened was that we took all the Federalist Papers and put them into one volume. And so people get a sense that they were produced at the same time and don't realize that these are, in fact, political documents attempting to persuade New York voters. And it was very important. One of the things I always try to emphasize, and one of the reasons I asked about ratification, is it wasn't a foregone conclusion. New York, the vote was 30-27 even after the Federalist Papers were published. And so it's a part of this conflict that I think often gets overlooked. But one of the things that encourages me is that we have people like you who have studied this and can talk intelligently about it. And I thought you were very kind to South Carolina about whatever you said about them. One generally shouldn't be all that kind to South Carolina's contributions to this.
Fantastic. So we'll jump into question 3 from Unit 3. And after I read it, then we will hear your opening. So in 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? We are ready for your opening statement.
The 19th Amendment and the Equal Rights Amendment both aim to create political and economic equality for women. The 19th Amendment relied on the theory of self-determination later explained by Robert Dahl, stating that women could pass their own political agenda once granted suffrage, which could include the removal of those laws discriminating against them. The ERA aimed to place sex discrimination under strict constitutional scrutiny instead of the intermediate level established in Craig v. Bourne, forcing the Supreme Court to strike down discriminatory legislation.
The ERA's broader construction made it controversial in the 1920s, as it would have removed protective labor legislation for women. Today, it could prompt immediate constitutional challenges to laws around maternity leave, the military draft, and the legal definition of rape. Depending on the outcomes of the current cases Altitude Express v. Zarda and Harris Funeral Home v. EEOC, a federal equal rights amendment could bring issues of sexual orientation and gender identity to strict scrutiny along with sex.
Self-determination through the 19th Amendment immediately led to the government furthering some women's interests. The Shepherd-Towner Maternity and Infancy Protection Act of 1921 was passed by Congress in anticipation of the women's bloc they expected to vote in 1924. The Bipartisan Congressional Caucus for Women's Issues has sponsored bills such as the Pregnancy Discrimination Act and Violence Against Women Act, which passed through advocacy from women. Because women's rights are up for political debate while men's are a given, women tend to act slightly more as a bloc. Therefore, the women's vote has made the difference for several presidential candidates, including Eisenhower, Clinton, and Obama.
Interestingly, some courts believe that the 19th Amendment would outlaw gender discrimination itself. Adkins v. Children's Hospital declared that the 19th Amendment had invalidated the common law practice of coverture, or men legally controlling their wives, and therefore it made a sex-based minimum wage law illegal. This case was later overturned under separate principles, but scholars like Reva Siegel still believe that because the 19th Amendment granted women political equality, it should have granted social equality too.
The 19th Amendment took place in the middle of a global movement to enfranchise women, behind countries like Australia and Afghanistan, but ahead of Great Britain. It was not the catalyst for global women's suffrage, but it did allow the U.S. National Women's Party to move on to international issues, like the Convention on Nationality, an agreement with the League of Nations that citizenship would be protected regardless of marriage or divorce. The World Women's Party, established in 1938, helped Jewish women escape the Holocaust and eventually received a permanent UN commission. Furthermore, after Balzac v. Puerto Rico declared that constitutional rights did not automatically apply to U.S. territories, U.S. suffragists helped Puerto Rican gain suffrage. Puerto Rican women gained suffrage in 1929.
Just over half the states have passed their own equal rights amendments, most of them in addition to ratifying the federal amendment. State ERAs usually resemble either the federal ERA or the Equal Protection Clause of the 14th Amendment. This creates discrepancies in rights granted across the states, particularly regarding the level of scrutiny for sex discrimination.
The Pennsylvania Supreme Court case Henderson v. Henderson established an absolutist standard banning any laws that classify based on sex apart from physical differences. Other states, like Virginia, simply use the federal intermediate standard. Additionally, state ERAs could make a federal ERA appear frivolous because critics can point to the many states functioning without these protections.
However, many states with individual ERAs have also ratified the federal one, and state ERAs do have benefits. Their protections apply to their state immediately, rather than being contingent on the federal amendment passing. They have also been used to expand LGBTQ rights, such as in Bayer v. Lewin, when the Hawaiian Supreme Court struck down a ban on same-sex marriage as unconstitutional discrimination based on sex. Additionally, they give credibility to a federal amendment by using the states as laboratories of democracy to test potential implications. Thank you, and we're ready for your questions.
Thank y'all so much. Here's a question. To the extent that the ERA gets at removing sex from government actions, can Congress pass statutes that are pro-women that still are constitutional under the ERA?
That's really going to be depending on how the Supreme Court interprets the Equal Rights Amendment. So under strict scrutiny, affirmative action programs have been allowed for different racial groups in Bakke v. Regents of California. So it would really depend on the level of scrutiny that the Equal Rights Amendment would establish. Because like we talked about in our statement, Pennsylvania has taken an absolutist approach. And in Henderson v. Henderson, they said that any state laws that classify based on sex are unconstitutional, except if they're based on actual physical differences.
Okay, so would the ERA provide strict scrutiny for sex difference, for statutes that make, based on sex differences, or based on sex, I should say?
it definitely would at least provide strict scrutiny, but it could go even farther.
Okay, so does the ERA make it harder for us to pass pro-women legislation than we have right now? Right, because right now we have intermediate scrutiny. So if we had higher scrutiny under the ERA, wouldn't it make it harder for us to pass pro-women legislation?
I think that a lot of legislation that is theoretically pro-women would actually be better if it was written in a gender-neutral way. One example of that is the Violence Against Women Act, which gives help to survivors of domestic violence. And that law was written specifically for women because more women are victims of domestic violence than men, but it has led to men who are victims of domestic violence having a really difficult time receiving services. So I think in large part, getting rid of pro-women legislation would support men while still supporting women.
Yeah, but I think you're confusing here. The Violence Against Women Act is based on the Commerce Clause.
Yes.
Not on the 19th Amendment or a state, or obviously not the federal ERA. So that seems like apples and oranges to me. I'm not sure that's a good starting point there.
Well, I'm just saying that the ERA under strict scrutiny might counter the Violence Against Women Acts only affecting women. But if a similar act still under the Commerce Clause, as you said, was written impacting both men and women, that would be allowed and would be equally helpful to women while still being helpful for men.
Yeah, interesting. Let me shift a little bit and get you to think about 19th, possible ERA, but also the 14th Amendment, and in particular, the Equal Protection Clause. Because how come we even need to worry about an ERA if there's in fact, a 14th Amendment, which we have, and an Equal Protection Clause? Help me understand the relationship here, or none, of those constitutional and legal principles.
I actually don't think we need an ERA because of the intermediate level established in Craig v. Bourne is pretty high, and also everything that supporters of the ERA wanted to achieve has already been achieved under Title VII of the Civil Rights Act. And I think that what we really need is an equal protection amendment, because not many people understand the full implication of the 14th Amendment besides like legal scholars. And I think that if we had
and you guys.
Yeah, I think that if we have an equal protection amendment that is applied to the states, then it will make it harder for the states to discriminate people in cases such as police brutality.
Disagree. I think that the 14th Amendment alone isn't enough. And I think this is because the ERA could address more than just sex discrimination. So depending on the cases Altitude Express v. Zarda and Harris Funeral Home v. EEOC, which will determine if discrimination based on sexual orientation and gender identity are sex discrimination, the ERA could have way bigger effects. And the Supreme Court hasn't determined any level of heightened scrutiny for discrimination against transgender people, and they've only determined a heightened rational basis for discrimination based on sexual orientation, which is nowhere near high enough.
I agree with Ellie that heightened scrutiny is more important in terms of Altitude Express and Harris Funeral Home. And in terms of Megan's point, I would be in strong support of a congruence doctrine, such as the one that's already been established for racial discrimination, basically stating that the Equal Protection Clause was reverse incorporated through Bowling v. Sharp, and I think that it should need to be applied the same way to the federal and state governments.
Okay. Was Robert Dahl correct when he said that once women get the right to vote, essentially they can get all the legislation they need?
I don't think that he was correct, because I think that just because we have these de jure laws that are in place doesn't mean that we have the de facto equality that women need.
Well, if there are more women registered to vote in every presidential election for the past 6 or 8, why aren't we electing more women? And why do we not need more protection by an ERA amendment or the other, the 19th? I'm sorry, I lost my train of thought for a second. If and I'm going to try to straighten out my question since I bungled it so badly. If we have way more people, women registered to vote, why aren't we electing more women? And why do we not need more constitutional protection?
I think that the reason why we don't have a lot of female candidates, can I finish my sentence?
You can finish.
Please.
reason why we don't have a lot of female candidates is because of the institutional structures that are so entrenched into our political system. I think that a lot of them, such as like campaign finances and closed primaries, don't benefit women the way that they benefit men.
Great.
Good
Thank y'all
answer.
very much.
Good answer.
Thank y'all very much. Judge Collins, what you got?
Want to really appreciate what you've done here. As you see, we're going to ask questions to make you stretch a little bit, and particularly the groups that we get a sense have something on the maybe a little bit better going for them. We're going to ask harder questions. So that's what we ended up doing here. So that's a good sign. But I'm really impressed with your control of the issues, control of the case law, and the sort of interaction between the culture as well as the constitutional principles and legal values, and how that mix comes together or doesn't over time and space. So I thought it was a really nice job, folks.
I agree with that, because it's a hard question and it's a tough issue when you've got a couple of amendments that are trying to get sex out of decisions, but we recognize that part of what we want to do is make sure that we actually have a country that is fair for women. So it's a tough issue. I think y'all did a nice job with it. You tossed in some gender stuff, which is very important, although could throw some sand in the gears to the extent that the public may be less ready for pure gender neutrality than sex neutrality. But I think y'all handled this in a real nice manner with a lot of citations, and not just a whole bunch of guesses, but actually using evidence to support your position. So I appreciate that quite a bit.
I'm repeating myself a little bit from the beginning, but this is a very, very difficult undertaking when you're not in school and you don't have time to meet after school, because there is no real schedule. We're not able to get together. We're not able to research together. We're not able to compare notes as easily, although I will contend that the technology is not hindering you as much as it is us. I really, really appreciate the effort that you all have made. I think you'll look back on this time in your lives, and I hope this is one of the bright spots. I hope this is one of the things that you take pride in, because it's just been so impressive to me that you all have done such a great job. And Ms. Brown, I know you're proud, and Hannah, you as well.
Yeah, really nice, folks. Really well done.
We're delighted to have you. We're going to read this real quick one more time today, just so kind of as a trigger mechanism for you, but you know the question by heart. This is Unit 4, Question 3. Article 1, Section 4 of the Constitution provides that state legislatures can determine the times, places, and manner of holding elections for senators and representatives, yet gives Congress the power to make or alter such regulations. What are the advantages and disadvantages of a uniform election process? What responsibility do state legislatures, state election officials, and citizens have in maintaining free and fair elections? And what are the advantages and disadvantages of the trustee and delegate theories of representation as they apply to congressional districts? We want to thank you for all the hard work you've done to get to today. The hard work ends and the fun part starts, and we look forward to hearing you. You can begin when you're ready.
Uniformity in the election process is advantageous as it helps to promote free and fair elections and allows for efficiency, consistency, and access. In a truly uniform system, each jurisdiction uses identical equipment and procedures for elections. In the US, we have some uniformity at the national level and within most states. There are some uniform national laws in America which ensure that people can still actively participate in the political process when they move states. The Help America Vote Act, passed in 2002, required states to phase out old equipment, which led to partial uniformity. Congress has made some regulations surrounding federal elections, the most notable being the Voting Rights and Presidential Election Day Acts. Congress should use their power to make more inclusive election laws. Increased regulations, such as eliminating caucuses and requiring open primaries, would extend the franchise by increasing participation and not requiring voters to choose a specific party.
While beneficial, uniform election laws have disadvantages. By giving Congress the final say, the balance of federalism would be further shifted away from the states, who are more knowledgeable about their citizens' needs. Establishing unfunded or underfunded mandates make it hard for states to comply with laws.
Having the federal government run all elections is not a wise decision when most are for local governing bodies. As the Anti-Federalists argued when they rejected Article 1, Section 4's election provision, people gain a stronger respect for systems when run by their community. Therefore, national election laws should be reserved for basic laws about franchise, eligibility, access, and structure. Election policy and the overall protection of free and fair elections can be entrusted to the states, election officials, and citizens.
State legislators have the responsibility to promote fair elections. Recently, the Massachusetts legislature has been considering the Empower Act, a bill that would allow cities and towns to lower their voting age to 16 for local elections. Additionally, states have fulfilled their duty to act as laboratories of democracy, experimenting with ranked choice voting seen in Maine. This system gives a greater voice to citizens and creates a more representative system. Furthermore, individual states work together to maintain fair elections. As of July 2019, 15 states and the District of Columbia adopted the National Popular Vote Interstate Compact, limiting the power of the Electoral College by giving the votes to the winner of the national popular vote.
Beyond state legislatures, state election officials and citizens play a role in promoting free and fair elections. State election officials play a large role in running elections, such as the Secretary of State and county, city, and town clerks. They have multiple responsibilities from handling ballots to candidate nomination. Citizen participation in the political process is necessary for a functioning polity and fairness. Recently, Massachusetts citizens passed a referendum in 2018 to propose an amendment to overturn Citizens United v. FEC, which protected a corporation's use of money in politics under political speech. Additionally, citizens are able to elect leaders that will protect elections.
Edmund Burke asserted that there are different theories of representation that have varying definitions of what it means to act in the best interest of the voter. The principle behind the trustee theory is that legislators are trusted to promote the common good, projecting a more unified national front and protecting minority rights. However, the trustee theory can be dangerous by taking away a level of accountability to the people and allowing legislators to make their own decisions regardless of what their constituents want.
Delegate theory instructs representatives to vote according to popular mandates and connects elected officials to their district. But delegate theory can also prevent elected officials from voting with their conscience and can make civil discourse challenging. Additionally, always favoring majority opinions can prevent social progress and mute minority voices. In the end, we believe officials are elected to represent the people and should rely on the people's opinion and the common good when making decisions. Thank you, and we are ready for your questions.
Well, thank you. And you hit it right on the second, Chris. That was pretty good. That's outstanding. You come in right on the second at the end of it. Let's hit just one more lick on voting rights and voting practices. When the national government cedes that much authority to local secretaries of state and to the states for how they run their elections, and there are different standards for purging voters and different standards for setting up the right amount of funding to hold the election and different standards for abiding with the Americans with Disabilities Act and those kind of things. Are we almost guaranteeing, when you let the states run elections, we're almost guaranteeing that there's discrimination, that there's not equal protection under the law for all the voters in this country? Haven't we just about guaranteed that?
I think that in some ways, yes, that is true, but there are ways that the federal government can try to prevent this, such as through the Voting Rights Act, which is a reaction to the discrimination against African Americans in voting. And we saw that in Section 2, they outlawed literacy tests which was upheld by Oregon v. Mitchell. And then in Sections 4 and 5, they also made a list of different states and places and that had a history of disenfranchisement, and then would require their new laws about elections to be looked over by the DA before they could pass them. But that was overturned by Shelby County v. Holder.
And I feel that under Article 1, Section 4 of the Constitution, Congress has the power to step in on local and state elections if they feel that they need to. And I feel throughout history, we really only see Congress stepping in state and local elections is when people are disenfranchised, such as the Jim Crow era in the South.
Connecting back to Lucia's point about Sections 4 and 5 of the Voting Rights Act in Shelby County v. Holder, this decision in Shelby County v. Holder actually led to the rise of voter ID laws. We can see this in North Dakota, and as well as in Georgia, where they moved their polling places, but this actually led to the disenfranchisement of some African Americans in the state. So since voter ID laws have risen, multiple groups have been disenfranchised, especially in North Dakota, the Native Americans who are living on reservations. Their voter ID laws require street addresses, and since they're living on reservations, they don't have them. This also applies to the homeless, because how are they supposed to get a voter ID law if they don't have anywhere to live?
Please don't leave Alabama out of that. We work very hard to disenfranchise voters down here. Sadly, we're too good at it, to my great dismay. Francine?
Well, you started answering my question that I had about disenfranchisement. Is there, you brought up a bunch of groups. Is there anybody else that would like to add anything else about disenfranchised voters?
I think,
go ahead. I also think that the disability group is also a group that is also being disenfranchised, because under some regulations about voter registration, some states don't oblige to the Americans with Disabilities Act and the fact that they need materials and equipment to make voting places being able to make disabled voters come to the election places and actually vote.
And again, oh, you can go, Lucia.
Thanks. Another place that we can see disenfranchisement is the disenfranchisement of felons in states such as Florida, where felons don't have the right to vote. And I think this is a huge problem, because first off, our jails and prisons should be a way for people to reform, not just be punished. And also it makes it so that they can't go through the social contract that makes it so that they should be abiding by our laws. And how are they supposed to agree to our laws if they don't have a voice in our government?
And right now, during the coronavirus pandemic, a lot of people are considering mail-in voting, which would disenfranchise, again, homeless people who don't have a home per se. And
It would also disenfranchise, just going off of what Liam said, it would disenfranchise people without internet, because as we talked to our state representative, Dan Carey, he mentioned how they're having a hard time getting the word out, and people without internet or a printer can't print out the request form to mail in to get a mail-in voting ballot for our upcoming special election.
And the courthouses are closed, so you can't go down there and do it in person because of that. Jocelyn, we've taken up a lot of time. You got a minute's worth? Go ahead.
Absolutely. Let's talk about Congress and what they can do. You mentioned that Congress has stepped in only when they've seen abuses. Is that the ideal system, or should Congress be more proactive?
I definitely think that's the ideal system, is for Congress to only step in when they feel that they need to, because a certain group of people are being disenfranchised and underrepresented. Like now with the coronavirus pandemic, there's a lot of talk about mandating mail-in ballots in some states, which wouldn't, well, not some states, and on a federal level, which wouldn't make practical sense, because a state like Wyoming with 300 cases doesn't need to spend the money. It need to spend the money to create like a mail-in ballot system. But a state like New York with over like 200,000 cases, they should mandate it. So I feel like, can I finish my sentence?
Yeah, please, go ahead.
So I feel like in those states, like elections, especially in times of emergency, it should be delegated back down to delegated to the states, because the states ultimately know, as said in Federalist 62, that the states know what's best for the people.
Thank you very much. That was a good one.
Very nice job.
Absolutely. Francine, you want to start for us?
Sure. So I just wanted to talk a little bit about, you did a great job overall, but I really enjoyed the follow-up responses. As you were responding to Mike's question, you actually started responding to the question that I was about to ask in terms of disenfranchisement. I'm like, oh, all right, then you're tying this all together. And the thing that I really liked is when I asked if anybody else wanted to add anything, not only did you tell me the groups that were disenfranchised, but you told me what was in place that was causing them to be disenfranchised. Because sometimes, you know, when we've asked this question, people have just kind of listed groups, but you've actually explained what's in place that's causing the disenfranchisement, which is good. And I really enjoyed when you were discussion of felons, and you said violating the social contract of, you know, allowing them to be part of society. I just enjoyed that you're able to sort of tie it back to Locke. So I like theory. So seeing how like this practical stuff actually applies to the theoretical issues that were the foundations of our Constitution, and you noticing the connections there, that was really enjoyable for me. And a lot of great specific examples, great citation of cases to back you up. So really nice job.
This is the best we've heard of the court cases, Francine, in a while. I thought they were pretty good.
Yeah. Yeah, great explanation of the court cases and walking us through it, not only with Section 4 with quick units, but also with Section 2. I'll mention that. Yeah, really good answers. And yeah, the question of like, what does Congress do in like these kind of pandemic situations? Like, Constitution gives that authority, the authority to administer elections to the states first, and then Congress can step in. So it's how do we balance that in regards to uniformity and also to allow for the creativity of states to do like ranked choice voting or do jungle primaries and those kinds of things. So I think throughout both your statement and your follow-up, like that discussion of balance really kind of comes through, which is where we all kind of tend to be. The example of broadband access as a limiting factor is something that we haven't heard a lot about, but it's very accurate. That if you can't get information, how do you know what to do in regards to that? Yeah, it was very good discussion, good conversation. Your idea about Congress expanding access to primaries, I'm a little since primaries are usually run by parties and not by nonpartisan government. So that's a very interesting, creative idea that I don't think I've heard of it anywhere else, but it'd be interesting to see I wish I could have time to ask, how would you implement that, since most party structures, and those are private organizations, tend to run those elections. So, but great discussion, wide range, and then also deep in your understanding of what, in your answers and in your reasoning. So thank you for that. It was wonderful.
I thought I saw your eyebrows go up when they brought that up. I didn't know I thought I saw you wave it down when I saw your eyebrows pop up.
I'm expressive when it comes to things that I'm like,
Harry, I thought you did. That's good. Because they've done such a great job of do what?
They gave us Shelby County.
That's right. Again, I mentioned it 3 times. But we've been laughing for 2 days. I live 5 minutes from Shelby County, and Francine and Jocelyn and Chris and I have had a bet for how many times I'd hear Shelby be Holder, and they said it 3 times in their thing. So I think the over and under, Chris, you may have won. I think we may be okay here. Okay, because they did such a good job of talking about the substance of what you said. Let me say 3 words of thanks before we go for Jocelyn and Francine and me, because this is our last hearing for the day 2 for 2 days. One of them is that if Bob Lemming and Mark Gage had not been willing to try this, we wouldn't all be here. Bob hadn't made the really hard decision to try to go ahead and have a national competition this year and have it online. Yeah, Roger's clapping for him. If they hadn't tried to do that, we wouldn't be here. And if Mark hadn't brought his IT skills to the game, we'd have had no chance. So we're so grateful to them. That's the first word I want to say. The second one is, Roger, this made facilitating a lot harder than usual. And old Kenton did a pretty good job. He got us in and out 15 times. Now, if he would just fill out our score sheets for us, we'd really get them right about now. But Chris, we can't thank you enough for all the work you did before yesterday, and today. And for today, thank you for that. And finally, I was teasing him at the first. My friend Roger, the happiest that I see him is when a team from Massachusetts does exceedingly well and makes him proud. You made the old man very proud today. I would like to have watched him watch you. Y'all were so much fun to watch today. And even though I couldn't see him, I was cheering him on. So on his behalf and on ours, thank y'all for being willing to try this. And thank you for doing it so skillfully. And now take him back to the assisted living and check him in before lunch. So he can have
Thank you so much to your teacher, because we know you would not have been able to do such a wonderful job if it wasn't for a wonderful teacher.
You're so right. Kelly, that was just remarkable. That was so much fun listening to them, and you could tell how well prepared they were.
Well, thank you for making it a conversation and not frightening. They were amazing, and I'm so proud of them. So incredibly proud.
They were. Bob, one of the things we've learned, and Bob Lemming said this a week or two ago in one of the meetings, we were all concerned about the Zoom technology and how this would work. And at some point along, Bob said, it ain't going to be the kids that have a hard time. It's going to be us that have to adjust and make it work. The kids do this all the time. Don't worry about it. And you were right. You've seen several times this weekend, they weren't the least bit intimidated by this, and they kind of pulled us through it. So you made the right prediction on that. If you don't mind, though, if we can get the virus solved, let's go back to Leesburg next year. Being in the same room with them is more fun, I think. Y'all stay safe and stay healthy.
I'm going to try to pull my strings on that one. Okay.
Yeah, see what you can do. Exactly right. And take care of the old man there. He's our buddy. God bless y'all. Thank you, Gary.
Welcome to start. So this is Unit 5, Question 2. Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? To what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses?
Richard Posner argues that
you can go ahead.
Richard Posner argues that there are two basic forms of privacy with which people are concerned: being free to go about one's business with minimal interference and to not have personal information used against them. Yet, neither the Constitution nor the Supreme Court has clear provisions protecting either. We agree with Posner on this. Posner argues that the existing privacy zones created by the court and are most debated are not the most important nor the areas most at risk. We disagree with Posner that issues of abortion and sexual privacy are not a significant concern to many Americans, but agree that the Supreme Court needs to better address privacy as a fundamental right in both the public and private spheres.
The problem with digitization is that so much data is collected, it's nearly impossible to opt out of disclosing it. We believe that the third-party doctrine established in Smith v. Maryland is outdated, and that the word voluntary can no longer apply. As Justice Roberts articulated in Carpenter v. U.S., when Smith was decided in 1979, few could have imagined a society in which a phone goes wherever its owner goes, conveying to the wireless carrier not just dial digits, but a detailed and comprehensive record of the person's movements.
Well, the court has acknowledged in Kylo, Jones, Riley, and Carpenter that today's digital world is completely different from the 1970s. They continue to adopt the same tools, which Posner argues is trying to put a square peg in a round hole.
Privacy is in jeopardy across the world today because people must give up their private data to operate in society. DNA, cameras, digitization of data, and the collection of vast amounts of data by public and private organizations leaves open the possibility of deep intrusions into people's lives and the misuse of data. Today, new police technologies that the founders could not have dreamed of already in the Fourth Amendment, such as infrared sensors, GPS, and stingray mimic devices, all pose a challenge to the Supreme Court to constitutionally protect privacy.
The passing of the Patriot Act legalized intrusions into people's most private places and papers. Section 702 allowed for surveillance and collection of data unknown to Americans. Section 215 allows the government to acquire secret court orders requiring third parties to hand over records. Nearly 20 years after September 11th, Congress is rethinking these broad powers and is working to pass further limits on government surveillance of American citizens and to create further checks on the FISA courts. The protections we have from our government are very limited and not expressly stated. Federal and state government officials are limited by the 1st, 4th, 5th, 9th, and 14th Amendments. State governments provide extended limitations on police beyond the Bill of Rights. For example, the cell phone location data in question in Carpenter v. U.S. would have required a warrant in Massachusetts.
There are even fewer privacy protections provided by businesses. Special relationships with lawyers, doctors, and financial advisors provide some privacy for our most personal data. Companies have collected consumer data for years, but Posner argues that increasing digitization allows for mass accumulation and centralization of data, which poses a significant threat to privacy.
Most protections from businesses are voluntary to avoid distrust in customer laws. For this reason, Congress and other government officials use avenues like the hearing process to bring light to consumer protection issues.
Posner argues, and we agree, that some major changes should be made to protect the privacy of Americans. First, people should be able to own their digital data away from companies' hands. Second, courts should stop trying to reshape the Fourth Amendment and establish a fundamental right to privacy and data, as it would pass both prongs of the substantive due process test. Privacy is clearly grounded in historical tradition and fundamental to ordered liberty.
As argued by Posner, if liberty in the Fifth Amendment's Due Process Clause can connote sexual freedom, the court should be able to establish a fundamental right to privacy, especially to protect and control our own data. Thank you, and we're ready for your questions.
Okay, well, thank you for that. Let me remind you to put away your notes, which we're supposed to remind you, so I've done that. Are you troubled by the fact you characterize privacy as a fundamental right, and you have an interesting construct for how it satisfies that. But are you troubled by the fact that it is not expressly protected in the Constitution or the Bill of Rights, and that by making it a fundamental right, you would give enormous power to judges to shape what this fundamental right is?
Well, I believe that, so what we have today to protect our privacy is the Fourth Amendment, which says it protects unreasonable search and seizure. But we also have this idea of a reasonable expectation of privacy, which was established in Katz v. US and later, or which the idea was established in Olmstead and it later established in Katz v. US and by Justice Brandeis. And so I think that this idea of a reasonable expectation of privacy, while it does pose some privacy, I think that making it a fundamental right would really put it into place and ensure that it's not violated in today's world.
For me, I think that the most important part of creating a fundamental right, for example, to own your own data and decide how it's used by companies, is the ways that it would be held to a strict scrutiny standard.
So I'm sorry, let me interrupt you. So you would apply this fundamental right not just to limit the power of government, but to limit the power of private actors. Is there any other right that is interpreted to limit the powers of private individuals?
So I think you're talking about the state action doctrine there, which basically states that these fundamental rights apply to the government, but not to private businesses. But we're generally in opposition to the state action doctrine. Personally, I think that it was created as an excuse for the court to nullify amendments they were uncomfortable with. We can see that in the civil rights cases in 1883, kind of nullifying the Equal Protection Clause of the 14th Amendment and forcing the legislature to pass the Civil Rights Act nearly a century later. So I think that this issue with it applying to private businesses, as you said, could be solved in one of two ways. It could be solved with legislation supporting it through the Commerce Clause, Article 1, Section 8, Clause 3, or it could be solved by an amendment or a fundamental right explicitly stating that it applies to private businesses.
Well, yeah. I'd agree with the outcome, but I'd have to disagree with the way we go about it. I don't think we could do it through the legislative process or the judicial process. The legislative process would rather argue way too much with each other due to being in opposition in different parties. So they would not come to an outcome very quickly. So it would take way too long. The judicial process has two different ways they go about it, and I don't think that they will come to an agreement on how to solve it. I think that the way we should go about it is kind of what Justice Brandeis articulated. He said that we need to look at the states as the laboratories of democracy and kind of try out legislation in one place and then see how it goes about throughout the country. I think currently today we're kind of seeing that with California's Consumer Privacy Act, which states that people have a right to be forgotten, a right to know what information is being stored, how that information is being used. And I think just by looking at them, we can see that we need an act like that. We need our own states to kind of step up and be the laboratories of democracy today.
I want to go to another question. Current COVID-19 emergency situation that we find ourselves in, the idea of preserving the public health and using public safety government's perspective for contact tracing and the tracking movements and things like that. How do you think courts should handle that versus the inevitable invasion of privacy issues that come with that? How should they balance those And is there precedent for how they should handle this?
Well, I think that we can see increased violations of privacy in a few different ways. We can obviously see increased use of technology, social media. You have to give up some rights in order to participate in society in the world today. You can see drone surveillance starting in China, but now coming into the United States and Florida and New Jersey. But I think that because we have a compelling state interest, this actually should really. A lot of these violations of our privacy are okay as long as they're doing it in the least restrictive manner. So I think that that's really like why it's being able to happen in a way that may appear that it's restricting some of our rights.
Do you think that once we've gone down this road, that the government is going to give back those? Are circumstances going to change where what is okay now is not later? I should probably turn it over to Caitlin because she needs to get her question in.
That's fine. They can answer that one.
Okay.
I think that the coronavirus pandemic is really showing just how crucial a fundamental right could be and how crucial the strict scrutiny standard could be, because the government has an outsized compelling state interest in surveying us in order to keep us safe right now, but the least restrictive manner requirement could help keep us safe in the future. And scholar David Hudson agrees with me that one really important point of that could potentially be forcing the government to later erase a database that they created right now.
So would this panel be okay with Apple sharing all of our GPS location data with the police and letting the police ticket anybody who's not socially distancing?
I think the sad fact is Google can do whatever it really pleases. I think that when we kind of sign up for these apps and we put our emails in there, we kind of sign these terms and conditions, which kind of waive away all of our rights. And it states that these businesses can actually change their terms and conditions at any time if they violate your rights, to kind of keep up with that. So I think that Google, while it can give up your GPS location to the government, I don't think it should. This is why I truly think we should overturn the state action doctrine and actually have legislation that applies to these businesses, doesn't let them get away with violating our rights. We can see that even Zoom in and of itself actually.
That's time.
I have to stop you there because it's time, but I would have loved to have let you go on, believe me. So, but. So let me start out just with some comments. Wow, that time went quickly, which is really an indication of just how good you guys are and how interesting what you had to say was. And I had really a million questions I would have liked to have asked. But wow, guys, it was a brilliant opening. It was very interesting. It was substantive. Lots of interesting references, but it wasn't. I never had the idea you were just, reading a list of stuff. There was a coherence to the opening, and a structure to it that was very interesting. And then. So what's going through my mind as I'm listening to it, I thought, well, I'm going to really test these guys. I'll ask them a question and see if they really understand what it was they were just telling us. And, I just got to say, for the most part, you hit it out of the park. I'm not sure that the use of a constitutional provision to bind private, the power of private entities necessarily would withstand sort of extended sort of analysis, but it's a very interesting question. And I just thought, and then I guess Alice, was you sort of pivoted right to the state actor doctrine, and really great. I mean, I would. If I had, my law students able to sort of have a discussion like this on this plane, I would felt like I died and gone to heaven. So really just first rate in every way.
Yeah, I will agree with what Andy said. And the other thing, just the reason we could have this conversation is because your level and depth of knowledge was so deep and so strong. You covered things that, one of the things you had a lot that we packed in just because time is, of course, of the essence, but a couple things that I thought were noteworthy that I hadn't heard from yesterday. from a similar discussion, the idea of state governments, and you didn't ignore that. And you talked about state governments with a higher level of protection, which of course they can provide. And, you know, the class I teach not law school students, but I teach a lot of undergraduates and kind of an intro to law and public policy. And I stress that all the time. I could have you guys come in and guest lecture because it was so good. The other thing that I really enjoyed was even in your discussion when you're talking about various things, you didn't say strict scrutiny necessarily. Oh, you did sometimes, but you used the standard and you used those things. It wasn't just a perspective of, you pulled in the court, the standards and things. It wasn't just my opinion is, you backed it with a lot of really good information, and you had specific proposals. That's a level of depth that frankly is extremely impressive, and you should be extremely pleased with your performance today.
Yeah, and to build on that, giving proposals is somewhat easy, but when you do it with all of the foundation that you all brought, particularly in follow-ups when you don't know what question's coming at you, I just thought it was super impressive. We love to see students pull out new information that they didn't cover in their prepared remarks meaningfully in follow-ups, not just to kind of like drop a case name, but to actually tease it out. And you did that beautifully. I also liked the proposal to look to the states. That's not something we've heard from a group yet. And when the COVID-19 outbreak hit, my team on the legal team at Peloton is analyzing 50 state laws and trying to figure out, is it a violation of federal privacy laws that in Ohio now we have to take our employees' temperature at the door before they're admitted to the workplace? Is that a medical exam? And so it was really, really interesting. You pulled in CCPA. That was very, very impressive how you kind of tied it all together. So excellent job.
Thank you.
So a shout out to, first of all, what great work, obviously, from your teacher and your coach. But the other thing I'll say is one of the sort of miraculous that we're able to sort of do it in this forum. But one thing we miss is when you're with us in person, we get a chance to be with your parents and see your parents. And so please just tell them how impressed we are with these young guys that who have obviously all an enormous future. So thank you, goodbye, stay safe.
Thanks so much.
You too.
So here is the question. In 1963, Dr. Martin Luther King Jr. said, "Never in the history of this nation have so many people been arrested for the cause of freedom and human dignity. What lessons can be learned from the Children's March in Birmingham, Alabama? What is civic engagement and what is its significance in American history? What responsibility, if any, do schools have to promote civic engagement?" You may begin when you are ready.
During the civil rights movement of the 1950s and 60s, African Americans and their allies fought against discrimination with nonviolent protests to secure basic human rights. Birmingham, Alabama was the epicenter of racial violence during the 60s. Civil rights leaders learned from the Freedom Rides that peaceful protests met with grotesque violence forced the hand of the government. The Children's March was a strategic move to draw the attention of the nation to the racial hatred of the South.
In Birmingham, the 1963 Children's March called on the nation's conscience. The Children's March showed the world that people should not have to wait for basic human rights, that civil disobedience can be a form of civic engagement, and that young people bring energy and risk to a mass movement for change.
Civic engagement is working to make a difference in civic life. It can vary from simply following the law to political and military service to civil disobedience and even radical violence. Civic engagement has been the cornerstone of American social and political progress, as seen through the efforts of the Patriots during the American Revolution, the moral charge of the temperance movement during the Second Great Awakening, and the collective planting of victory gardens during the World Wars.
Such civic engagement produced major changes like women's suffrage in the past and promises even more in the future. Legal and extra-legal actions by leaders like Susan B. Anthony and Alice Paul forced the President and Congress to support the 19th Amendment. Today, young Americans are protesting over climate change, as seen in the case Juliana v. US and the global students' climate strike.
While the most memorable civic engagement is major movements like the Civil Rights Movement, everyday civic engagement like military service, teaching, joining voluntary associations, and helping our neighbors is more important to the vitality of our democracy. When Alexis de Tocqueville visited America in the mid-19th century, he was awestruck by the everyday civic engagement that made American democracy work.
Thank you very much. Outstanding opening statement, but we do have a few follow-up questions.
Yes. No, civic engagement, however, does not always create positive change, nor is it always virtuous. In the many years of Jim Crow, individuals saw their duty to the community as denying other people's rights. More recently, citizen-led Proposition 8 banned gay marriage in the state of California. While the courts found it unconstitutional in Perry v. Schwarzenegger, it serves as a prime example of civic engagement leading to the oppression of minority groups.
For a democracy to function, the people must take responsibility to carry forth key values and principles. Aristotle argued that a successful constitution needs both good laws and good men, virtuously engaged citizens. Accordingly, he saw education as central to a functioning polity, while framers like John Adams and Patrick Henry believed that religion inspired civic engagement. Today, secular education must take on responsibility to teach civic engagement.
Schools must teach the values of civic engagement, and students need opportunities to experience participation in civil society to understand its rewards. This requires both education and practice. A 2015 study of the We the People program found students who took the class were more likely to believe that it is their responsibility to be involved in their community. Yet a March 2020 study by the National Commission on Public Service found a severe lack of high-quality civic education for students across America. This commission argues for widespread adoption of national state-based best practices and cited civic education as an essential requirement for fostering a culture of service in America. Quote, when 22% of American adults cannot name any of the three branches of government, it is well past time for the country to take action. End quote. The report calls for federal investment in civic education and incorporation of service learning within schools. Massachusetts is leading the way in civic education with the 2018 Civic Education Law, which provides a nonpartisan education of civics in 8th grade and the completion of a civics project in both 8th grade and high school. Thank you. We are ready for your questions.
Thank you. Timer, I'll ask you to add a few seconds on the end here for my judging error. Sorry about that. There was a long pause there, and that's my fault.
Sorry. Yeah.
No worries, no worries.
Okay,
yeah, no worries.
Well, we're still going to have a great conversation. It was a great opening statement.
Of course.
And we have some follow-up questions.
Would you talk a little bit about the ways in which the Constitution either supports or thwarts civic engagement?
I think one way it supports it is through federalism. So we see with the Article 4 of the Constitution guarantees all states a Republican form of government, which means that which makes it a lot easier to engage civically, because it's a lot easier to engage with a close state government than a distant federal government. Recently, we've been able to meet with our state representative, Dan Carey, which has been, and he's talked to us about how he has office hours where people are able to meet with him, and it's a lot easier to interact with the state government than the federal government.
I think 100% the First Amendment. The First Amendment is the most important because it allows people to have that right to speak their mind and have that kind of voice to be able to say what they want in their government system. But we see this kind of oppression on this right given during the recent COVID-19 crisis, where a pastor in Florida had a religious service at the end of last month, and he was arrested for giving these services. But his plea to during his sentence was that his rights of the First Amendment were being violated.
I also think that the Constitution does support civic engagement because in the 15th, 19th, and 26th Amendments, it expands voting rights, and voting is one of the best and easiest way for most people to get involved with the government and be civically engaged.
Do those amendments also limit engagement?
I don't think they limit engagement at all. I think they have expanded the right to many groups of people, and I think that just shows like how hard people have fought for these rights and shows that everyone should make sure to practice them because of how important they are.
Are there
I
any
think,
limits on, are there any limits on engagement?
yes, I think there is definitely limits on engagement. We see Kentucky passing voter ID laws for the upcoming fall elections, and I think that limits the ability for people to actually go out and have that exercise right to vote, because not many people have the ability to get those voter IDs.
Let's turn our attention to civil disobedience. Is civil disobedience always justified in a democracy?
I don't think it's always justified, but there are a lot of situations where it's justified. I think civil disobedience goes back to John Locke's idea of the social contract, where the government derives its power from consent of the people, and that if they violate the social contract, then people should have the right to break the laws because the government no longer is getting the consent, therefore they no longer have power. However, in situations where the government isn't violating the social contract, I don't think civil disobedience is justified.
To add on to Sam's point, I think in King's letter to Birmingham jail, we see his description of civil disobedience as a way of people breaking the laws to make the laws stronger. And by breaking these laws, people are allowing to have this public attention to these unjust laws. So civil disobedience is really important.
Let's go back to voting. Should we have mandatory or compulsory voting here in the United States? Why or why not?
I do not think we should have mandatory voting because I think that everyone has I think it kind of falls under like freedoms. Like we have the freedom to choose what we do. We have the freedom to choose what we say. So I think that we should be able to choose whether we should vote or not.
I think that that forcing people to vote is a violation of the First Amendment. I think that the First Amendment gives you the right of freedom of speech, and that includes the right to choose to not say anything, to not be involved. And also, I think instead of forcing people to vote, I think it's better for politicians to actually go out and give people reasons to vote, which we have been seeing happening a lot in the recent Democratic primaries.
I think instead of mandatory voting, we should actually have mandatory civic service. We see with Israel, 18 to 25-year-olds have a mandatory, some type of mandatory civic service, rather having being able to be in the military or helping out in the community. I think that would be an important part and actually increase civic life and moral responsibility in our country.
Recently, there's been a number of demonstrations against the COVID virus and the quarantine. Do you think we're going to look back at this as a good example of civic engagement or not?
I think that it is a good example of civic engagement because as Martin Luther King said in his letter from Birmingham jail, that like sometimes people just can't wait anymore. And I think that a lot of these people protesting are people that are living paycheck to paycheck and they need something to happen so they can continue to support their families and keep their lives moving. So I believe that this is justified. It's their last idea that everything else they've tried didn't work. So they're working to try to fix their lives and keep themselves able to function.
I would have to disagree. I think that it's unnecessary to protest against these social distancing restrictions. I don't think in that situation the government has violated the social contract. And while there is an argument that these people are doing it so they can go back to work, the government has tried to compensated people who are working, who are out of work, with the stimulus check as a way to keep people from losing their money.
Well, outstanding job, Massachusetts. I heard some things in both your prepared statement as well as in your follow-up responses that we haven't heard so far today. I like the fact that you broadened civic engagement out, especially in your opening remarks, to not just what protesting against the government, but also civic engagement in terms of helping further the cause of government. You gave the example of Victory Gardens, and that was a nice, really nice touch. I also love the fact that you're able to, on the fly, connect your arguments to philosophical and historical examples. I mean, that's really quite impressive. The response to civil disobedience was, I felt, pretty much spot on. And not only did you go back to Locke and social contract, which was outstanding, but then more specifically to the question, you reference Dr. Martin Luther King's letter from the Birmingham jail, and which is an eloquent discussion of when civil disobedience is justified. And to put a cherry on top, you said what King did, and that is that it's actually, if you do it the right way, it's the ultimate respect for the law. I was super impressed from start to finish.
Thank you.
Thank you. Thank you.
Thank you.
Let me add on my positive comments. I agree with everything that's said. That broad definition of civil engagement was very effectively presented. I like the idea also you brought some data in, some polling data. I thought that was good to strengthen your particular position in terms of civic education in the schools.
I'm disappointed that we didn't have more time. You did an outstanding job. Great story in your presentation with right on examples. You responded to all of our questions in a most impressive manner. Congratulations to you, and congratulations specifically to you